Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract issues. Today I'm going to talk about what are some of the things that can make a non-compete unenforceable. So, for the most part, if you're a professional, before you start an employment relationship with an employer, they're going to make you sign an employment agreement or perhaps an independent contractor agreement. And then within those two documents, there very likely will be some kind of non-compete. And so a non-compete is a restrictive covenant, and there'll be a section in your contract about restrictive covenants. And these are things that you either can't do during or after the employment relationship ends. And so for a non-compete, there are kind of three parts to any non-compete. It's the scope of it, meaning what is it preventing you from doing, for how long, and then within what geographic area. So let's just take a doctor, for instance. Let's say it's a general surgeon. The non-compete would say you can't practice as a general surgeon for 1 year within 15 miles of your primary practice location. That would be a non-compete. So what are some things that can make a non-compete unenforceable? Well, first, there are a handful of states where non-competes are completely unenforceable via statute of that state. So you need to first look, am I in a state where non-competes are unenforceable? And if that is the case, then you're good to go. Even if there's a non-compete in your contract, it will not be enforced in that state if they're completely unenforceable. So that's the first thing. Are you in a state where they're completely unenforceable anyway? Now, assuming you're in one of the other, 45 states where they are enforceable, the courts in almost any state are going to take into account those three things I talked about. So they're going to say, is it reasonable in scope? Is it reasonable in time? Is it reasonable in kind of a geographic restriction? Now, this fluctuates state to state. There is no set rule, meaning, if it's under 1 year and more than 20 miles or prohibits just what your primary skill. There's no set. It's kind of a case-by-case basis. So I guess you kind of have to figure out, all right, what is considered reasonable or not? And that's going to be dependent upon a number of things. So let's say you're in sales and let's just say you do software sales in Atlanta, Georgia. Well, the non-compete could say you can't do software sales within, the county where you currently are located for 2 years. In that case, probably enforceable. In almost any non-compete, you'd want to keep it, down to 12 months, no more than 12 months. But in that scenario, it's stopping you from doing the specific thing that you're doing for them for a reasonable amount of time within a reasonable area. Now, if they said you cannot do sales, meaning any sales for any industry for 5 years within the entire state of Georgia, well, that would be completely unreasonable and likely not enforceable at all. Now, there will be language in most non-competes that say if a court finds this is not enforceable, then they'll either offer some alternative options, meaning let's say they say it's a 2-year non-compete, then they'll step it down and say if a court finds 2 years unenforceable, then it'll be stepped down to 18. If they find 18 months unenforceable, they'll step it down to 12. Or if it's, 5 counties, move it down to 1 county. Or if it's 50 miles, move it down to 20 miles, down to 10, down to 5. Most smart employers will put that language in their contract. What they don't want to do is have the judge determine specifically what they consider reasonable. And most judges will abide by the terms of a contract if they can. And so if there is some kind of step down, that's exactly what the judge will do, is they'll just kind of step down until they find a spot that they think is reasonable. So some things that would make it unenforceable, as I said before, is if the scope is way too broad, if the time period is way too long, or if the geographic limitation is much too far. Those are the three factors. So when you're looking at a non-compete and determining whether it would be enforced or not, those are the three things you need to take into account. I would suggest if you're concerned whether something you're signing is enforceable or not, or if you're in a state whether it's enforceable or not, contact an attorney who handles employment contracts and see what they have to say. As I said before, there's almost no hard and fast rule beyond it being completely unenforceable. So it's more of just kind of a judgment call of, all right, what kind of industry are you in? What's reasonable within that industry? Are you in a rural, community versus New York City? Obviously, 15 miles of New York City is going to be a lot different than if you're in some kind of rural town in Idaho, where 15 miles, there could be no one else within 15 miles for you to compete against. Or in New York City, that could knock out potentially thousands of opportunities. So those are all the things that kind of take into account whether it is considered unenforceable or enforceable. If you have any questions about your employment contract, independent contractor agreement, feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. All right, appreciate it. Thanks.